consent order for me.
Because it's inappropriate. It is inappropriate to ask to withdraw in the midst of sentencing.
It's not.
And you have no authority. Do not interrupt me. You have no authority to show that that is appropriate.
Well,
it will be denied. Don't do that, counsel, because you don't want to go there with me. Not today.
Judge, I am being respectful as possible.
Good morning, Your Honor. Attorney Michael Kelly, 77187 on behalf of Ms. Wilson.
Your name, ma'am?
Elizabeth Wilson.
All right. Date and time that the court had set for a restitution hearing at the request of the defense. I also have a motion to withdraw, which seems rather weird to me. So, wherever you'd like to start.
Your Honor, just in terms of the motion with withdraw, I did submit that request in advance, hoping that we would have the opportunity to be heard on that prior to today's hearing, not to cause any prejudice to my client. I am here, Your Honor, for today. I think it's the most efficient use of my time that I'm going to stay on with Ms. Wilson for purpose of the restitution hearing, since I'm already here.
Well, just so that we're very clear, and the reason the court did not sign the order is because the restitution hearing, particularly at your request, is part of sentencing. And I would not permit counsel to withdraw in the midst of sentencing. It just would not happen. So it's good that I don't have to deny the motion, but I wasn't signing it. But all right. So it's withdrawn. What are we doing with regard to the restitution? In my understanding, the victim is here via Zoom.
She is here, Your Honor. I wasn't sure. Thank you, Your Honor.
Well, that's what I think I was informed of that. Ma'am, are you here?
Oh, yes, I am.
Okay, there you are. Okay. Thank you very much. All right. What are we doing?
Your Honor, has the court also received the estimate that was provided by Michelle Miller Prince from Great Lakes Village Range for the repairs?
The one that is 3,229.08.
That is correct, Your Honor.
Yeah, I do that.
So, Your Honor, we could proceed to the hearing. I'm not sure if defense counsel, now that Ms. Miller is here, is willing to stipulate to the rest of the matter, if we do need to have a hearing.
We're here for the hearing, Your Honor.
Your Honor, will the court allow Ms. Miller to testify via Zoom?
That is how she's appearing. So yes, I will.
Miller, are you able to testify right now, or are you busy with something else?
I'm working.
Okay. Is there a point, Ms. Miller, that you're going to have a break, or a point where you can answer?
In about an hour and a half. In about an hour and a half. In about an hour and a half, I'll be done with this head, and I'll have this client under the dryer.
Got it. And then you'll be able to take some time and testify?
Yes, sir.
Okay. Then what I'm going to do, said about an hour and a half. What is it? Okay. All right. Because her testimony is needed.
Can we have just a moment to confer with defense counsel to see if that's going to work?
Yeah, Your Honor, I didn't block off a whole day for.
Well, counsel, you're in this case. Whether you blocked off a whole day or not, is irrelevant to me.
I'm in this case because you wouldn't sign the consent order for me.
Because it's inappropriate. It is inappropriate to ask to withdraw in the midst of sentencing.
It's not.
You have no authority. Do not interrupt me. You have no authority to show that that is appropriate.
Well,
it will be denied. Don't do that, counsel, because you don't want to go there with me. Not today.
Judge, I am being respectful as possible.
This discussion is about more than just setting a court date. It is about whether a defense attorney must stay on the case until sentencing is completely finished. Judge Simpson explains that the restitution hearing is part of the sentencing process. If the attorney is allowed to leave before that hearing, Ms. Wilson could end up without legal representation during an important financial decision. The attorney argues that he did not expect to spend the entire day in court, but Judge Simpson says that is not a legal reason to withdraw. The judge also points out that interrupting the court does not help the attorney's argument. If the attorney believes he can leave the case now, He must show a legal rule that allows it. The victim also needs to testify because the defense asked for a hearing instead of accepting the repair estimate. That means the court has to schedule the hearing around the victim's availability, even if she is at work. Do you think the attorney's frustration was understandable, or did the way he expressed it hurt his credibility? The bigger question is whether the defense will continue challenging the restitution or decide it is better to accept it after considering the legal risks.
Right.
Good afternoon, Your Honor. Ashley Lonnie, calls for people.
Good afternoon, Your Honor. Michael Kelly, P77187, on behalf of Ms. Wilson, who's present, standing to my right.
Elizabeth Wilson.
All right, what are we doing?
Your Honor, at this time, I believe my client is prepared to stipulate to pay the restitution.
Your Honor, do I have to pay the full amount?
I'm sorry, go ahead. Well, hang on a second. All right, here's what I'm gonna do, and then I'll answer your question. Okay. I'll order restitution in the amount of $3,029.08. Okay. And then my next, when you say, do you have to pay the whole amount? What are you asking me, ma'am?
Well, I've been advised that this is not a trial and I need to get my paperwork, please.
Okay, go ahead.
Due to the fact that I'm the only person that was there, she was driving a Cadillac. She wasn't driving the vehicle that has been stated in the police report. Also, she did not wait for the officer to show up so the officer could look at her vehicle. Anything could have happened to her vehicle from the time that she left Wendy's and from the time she got home. And then I didn't receive a phone call from the officer till 4 or 5 hours later, stating the fact that that this had happened. And all she had to do was send pictures over. And that justified the fact that I hit her car when I didn't. I would have stayed if I hit her car. It's what car insurance is for.
Hold on a second, ma'am.
Mhm.
Okay, can we? Go ahead.
Sitting on the drive-through, there's just no way I could have done that kind of damage. You're sitting still. It would have affected.
Ma'am, let me just stop you. And I know you got something you want to tell me. Hey, but there was, but I read it. There was a no contest plea to these charges.
Right.
And now you're disputing them?
I took that because I was not informed that I had to pay restitution. I took that because that was the cheapest way out.
So, okay. Go ahead.
That's okay. Thank you very much for your time.
Is there anything else? I mean,
there's no proof of anything, and it doesn't make sense to me. It really doesn't. I mean, the officer wouldn't look at my vehicle. I offered to bring it in, like I've been cooperative.
Right. Well, but understand that the only thing that I'm going to know when I'm looking at this, because it was a no contest plea, is what's contained in the report. And as part of a no contest plea, I accept what's in the report is true in terms of making a finding. Now, where you got the information that restitution may not happen, I don't know, and I'm not getting into that. I will just say that when something like this happens, the issue of restitution, a lot of it is statutory, it just occurs. Okay. So going back to your initial question of the payment of the restitution. Now, how can you pay that? Let me ask you that first.
I can't. I don't have a job. But, it's the law. I've always followed the law, never been in trouble with the law. So, I mean, I just thought maybe you would take in consideration the fact that there's no proof. I mean, she just sends pictures over.
Okay. So here's the thing that you have to understand about this, and that's why I keep going back to the no contest plea. once you enter that plea, then Miss Miller basically becomes a crime victim. And pursuant to the statutes, then she's entitled to restitution. That's a simplified version. Okay. So in essence, she's entitled to be made whole. Yeah. In terms of restitution, and now that it's been stipulated to, I don't know that there's much the court could do. It really becomes an issue of how it gets paid. And it's also so that you know, because I know you've been in the courtroom with other cases, I'll try to work with people, but I have less flexibility with the issue of restitution. In fact, in a lot of ways, I have none. I can set it up so that it's paid over time, certainly, but I can't waive any part of it. My hands are tied in that respect.
This is the main legal issue in the hearing. Miss Wilson wants to argue that she did not cause the damage. However, by pleading no contest, she allowed the court to rely on the police report when deciding responsibility. A restitution hearing is usually about how much money the victim should receive, not about deciding who committed the offense. That issue was already settled when the plea was accepted. Miss Wilson says she took the plea because it seemed like the cheapest and easiest option. While that may explain why she made the decision, it does not change the legal effect of the plea. At this point, her attorney agrees to the restitution amount. Because of that agreement, the prosecution no longer has to bring the victim to court to prove the repair costs. Judge Simpson stays calm because he is separating two different issues that Miss Wilson keeps mixing together. One issue is whether she legally owes restitution. The other is how much she can afford to pay each month. The judge explains that he can adjust the payment schedule based on her financial situation, but he cannot simply cancel the money owed to the victim. The defense now needs to focus on creating a payment plan that Miss Wilson can realistically afford while staying in compliance with probation.
So I needed to go to court and prove all that stuff in order to avoid paying this then, right? That's what I needed to have done. Going to trial.
Ma'am, I can't answer that.
I know, I'm sorry. I'm not getting any answers, so I'm coming to you.
Because there are so many. The reason I can't answer it is because there are so many reasons why somebody may not go to trial or goes to trial. There are a whole lot of different considerations that play into that. So if it were a simple yes or no and I had an opinion about it, then I'd tell you, but I can't, in all honesty, say that.
Okay.
Okay.
Well, thank you for listening.
Not a problem. So in regard to the restitution, do you know how you're going to get that paid or how you're going to pay it?
I'll figure it out.
Okay. So, but I got you. But I need to sort of put something on it to say how you're going to do it.
It's $50 a month, according to my probation right now.
Pardon?
$50 a month.
$50 a month is what your payment plan is to us.
Yes.
Your Honor, that's for the fines and costs.
Fines and costs. All right, why don't we do it this way? Because you say you're not working right
now. No, I have a job, but I just applied for it and it takes another month to see if I get it. So
got it. Okay. So, Ms. Polero, why don't we do this? Have you made any of the $50 payments yet?
Yes, I've already made 125.
That was on the
50.
date of sentencing, right?
Right.
Okay. And then your next payment was going to be the 50.
Right. I'll make that today when I leave.
Okay. Are you making that in cash?
No.
Okay. So here's what I'm going to do. Let's set you have her review is February 24th of 2027. All right. So here's what I want. The $50, so you'll need to pay it in cash, right?
Like come in here and actually pay
and
it?
actually pay it.
Okay.
The reason I'm gonna do, you have to do that is because I'm gonna have what you can pay in terms of the $50 go to the restitution.
Oh, okay.
Okay, but I can't do, if you were gonna pay it on a card, I can't do it that way.
Okay.
Okay, so it's gotta be cash that you come in and pay.
Okay.
All right, so I realize you set up a payment plan. She's now got this balance. It's gonna be $50 per month until probation tells you otherwise. If you get employed, then it might be something else.
Okay.
Got it?
Yep.
And you just have to pay that in cash. It's to go to the restitution and then be paid over so that balance can go down. Makes some sense to you?
Yes.
All right. And then we'll do it that way. So I've ordered it. It's payable through the court in accordance with what I've said and at the direction of probation.
Okay.
All right. Thank you.
And Your Honor, lastly, I just want to make sure that my appearance is being removed as attorney of record from this point forward.
File an order requesting that you be removed this attorney of record as one would do at the conclusion of a certain point, and the court will.
In the end, Judge Simpson orders Miss Wilson to pay the full restitution. He sets the payment at $50 per month and says probation can adjust the amount later if she gets a job. Throughout the hearing, the judge makes an important point. The victim has the right to receive restitution, but the payment schedule can be changed based on the defendant's financial situation. Even though Miss Wilson is unemployed, that does not erase what she owes. Instead, the judge creates a payment plan she can manage. He also explains that her payments must be applied directly toward restitution. The defense's strategy changes during the hearing. At first, the attorney wants to withdraw from the case and seems ready for a contested hearing. Later, he agrees to the restitution amount. Once he does that, Miss Wilson's arguments about the vehicle, the delayed police report, and the photographs are no longer enough to challenge the case. Those issues should have been raised before the plea was entered. Miss Wilson continues saying there is no proof, showing that she does not fully understand what her no contest plea means. Even though she did not admit guilt, the plea still allowed the court to convict her, sentence her, and order restitution. Do you think better legal advice before the plea would have changed her decision? Or was avoiding a trial still the better choice? This case is a reminder that a no contest plea can still lead to a conviction, financial penalties, and restitution. Anyone accepting a plea should fully understand all of the legal and financial consequences before making that decision. If you found this courtroom case interesting, be sure to like the video, share your thoughts in the comments, and subscribe for more real courtroom breakdowns.